Hi, I'm Damin Murdock, principal lawyer at Leo Lawyers. Although this looks and sounds like me, what you're watching is my AI avatar, presenting from a script that I've personally written and approved. One of the biggest mistakes I see in the construction industry is people spending weeks negotiating the contract price, but only a few minutes reading the terms and conditions. Problem is that it's often not the contract price that determines who wins or loses a dispute. It's the clauses hidden in the fine print. I've seen contractors lose hundreds of thousands of dollars because they missed a notice deadline. I've seen principals discover they couldn't recover delay costs because their liquidated damages clause was unenforceable. And I've seen parties assume the contract protected them, only to discover that legislation overrode what they had agreed. Today, I'll walk you through some of the biggest construction contract traps that can end up costing contractors and principals enormous amounts of money. Let's start with one of the most common traps: contractual time bars. Construction contracts almost always require contractors to notify the principal within a specified period if they intend to claim additional time, additional money, or delay costs. Those notice periods might only be 5 days, 7 days, or 14 days. The problem is that many contractors become focused on keeping the project moving and leave the paperwork until later. Unfortunately, by the time they submit their claim, it's often too late. Even where the contractor clearly deserves an extension of time or additional payment, the claim can fail simply because the notice wasn't given on time. This was recognized by the Western Australian Supreme Court in CMA Assets Pty Limited versus John Holland Pty Limited, where the court acknowledged that these provisions can produce harsh outcomes, but nevertheless confirmed that courts generally enforce them according to their terms. The lesson is simple: don't wait until you've quantified your claim before issuing notice. If an event occurs that may entitle you to additional time or money, issue a protective notice immediately and preserve your contractual rights. Trap 2, no damages for delay clauses. The next trap catches many contractors by surprise. Most contractors understand they may receive an extension of time if delays occur. What they often don't realize is that an extension of time doesn't necessarily entitle them to recover the additional costs caused by that delay. Many construction contracts contain what's known as a no damages for delay clause. These clauses say that although the contractor may receive extra time to complete the works, they cannot recover their additional costs arising from the delay. Those costs can be enormous: site supervision, equipment hire, labor, insurance, overheads, plant sitting idle. All of those costs continue while the project is delayed. In Lucas Earthmovers Pty Limited versus Anglo Gold, Ashanti Australia Limited, the federal court enforced exactly this type of clause. Although the contractor experienced delays, the contract clearly excluded claims for losses, costs, and expenses arising from delay or disruption. The court found that the contractor's only contractual remedy was an extension of time. That's why contractors should always check whether a delay clause gives them additional time only, or whether it also allows them to recover the financial consequences of that delay. Another clause that's regularly misunderstood is the exclusion of consequential loss. Many people assume these clauses only exclude remote or indirect losses. That's not always true. Some contracts define consequential loss extremely broadly. In fact, they may exclude claims for loss of profits, loss of opportunity, loss of future contracts, and many other commercial losses. In McMahon Mining Services versus Cobar Management, the New South Wales Supreme Court interpreted one such exclusion broadly enough to prevent recovery for loss of other contracts. The important point is this: never assume you'll be able to recover every loss you've suffered after a breach of contract. The exclusion clause may significantly limit your entitlement. Liquidated damages are intended to provide certainty. Instead of arguing later about the amount of loss caused by delay, the parties agree in advance on a daily amount payable if completion is late. But sometimes parties choose an amount that's unrealistically low. Perhaps they select $1 per day or some other nominal amount without properly considering the consequences. The courts have shown that simply inserting a token figure doesn't necessarily mean that's the only remedy available. In cases including Capello versus Hammond, in Simons, and Carbone versus Fowler Homes, the courts carefully examined whether the parties genuinely intended those nominal liquidated damages to operate as the exclusive remedy. If that's your intention, The contract should say so clearly, otherwise the principal may still argue they're entitled to recover greater damages through ordinary legal principles. Now let's look at a trap that affects principals. Many principals assume that if a contractor hasn't complied with the payment provisions in the contract, that's the end of the matter. Not necessarily. In New South Wales, contractors also have rights under the Building and Construction Industry Security of Payment Act. That legislation creates an independent statutory payment regime. In Walter Construction Group Limited versus CPL, Surrey Hills, Pty Limited, the court confirmed that a contractor doesn't necessarily have to establish its contractual entitlement before relying on the statutory payment process. In other words, even if there's a contractual dispute, a contractor may still be able to pursue payment through security of payment legislation. That's why principals need to understand not only their contract, but also the legislation operating alongside it. Another common misconception is that subcontractors can simply be paid once the head contractor receives payment from the principal. Australian law generally doesn't permit that approach. Many pay when paid clauses are prohibited. The High Court confirmed this in Maxkin Construction's Pty Limited versus Vadas. In that case, a retention arrangement linked payment to events occurring under the head contract. The court held that the clause operated as a prohibited pay when paid provision and therefore couldn't be enforced. The practical lesson is that parties can't simply shift payment risk down the contractual chain through clever drafting. If the legislation prohibits the arrangement, the clause is unlikely to survive. Finally, let's talk about liquidated damages from the principal's perspective. The principal is entitled to protect itself against delay, but the amount chosen must represent a genuine estimate of the likely loss. If the amount is extravagant or designed simply to punish the contractor, the clause may be unenforceable. The Western Australian Court of Appeal reaffirmed this principle in Spears Earthworks, Pty Limited, versus Landtech Projects, Corp. Pty Limited. The court made it clear that liquidated damages shouldn't operate as a punishment. Instead, they should represent a genuine attempt to estimate the loss that delay is likely to cause. Construction contracts are far more than a scope of work and a contract price. They allocate risk. They determine who bears the cost of delays. They control how claims must be made. They can limit or even completely remove rights that parties assume they have. Understanding these clauses before signing is almost always far cheaper than arguing about them in court later. At Leo Lawyers, we regularly advise contractors, developers, and principals on contract drafting, reviews, and disputes across New South Wales. If you'd like tailored legal advice, you'll find our contact details in the description below, or visit us directly at leolawyers.com.au. Thank you for watching, and I'll see you in the next video.